Welcome to another presentation brought to you by CPDtv. CPD, at your convenience.
Good day. Welcome to this session of the Protection of Personal Information Act, also known as POPI. My name is Jane Apasamy, and I'm going to take you through the sections of the legislation, what it means for you as an individual who has rights under this piece of legislation, and I think more importantly, from your business and your practice perspective, how you can comply with the requirements of the POPI legislation, whilst at the same time making sure that you instill good business habits into your practice. I would like to paint a picture of a world, before we get into the legislation, with absolutely no technology, no social media, no cell phones or laptops or tablets. Communication can only happen if you're sitting in person with somebody face to face, or if you're chatting to them on the telephone, and by that I mean a landline telephone, or if you pop something into the post and there's a door-to-door postal service. Can you imagine such a world? I want you to think about the concomitant privacy challenges that you would face in this kind of world with no technology, no social media, no cell phones, laptops, or tablets. And then I want you to move into another space for just a minute and imagine another kind of world. In this particular kind of world, you have absolutely every possible type of technological device you can possibly imagine. You have social media access. The world has Wi-Fi wherever you go. You have full access to your cell phone with no restriction. You have laptops galore. You have tablets literally coming out of your ears. In the second world that we're busy in right now, communication hardly happens in person. It hardly happens on the landline telephone as we used to know it, and it hardly happens via a door-to-door postal service, known in this world as snail mail because of its slowness. In fact, in this second world, communication happens almost always electronically and instantaneously. The remote control for instant gratification is what rules this world. I want you to do the same thing you did in the first world. Think about the privacy challenges you could potentially face in this technologically crazy world. And now compare the two. So what am I asking you to do in the two worlds juxtaposed with each other? I guess I'm asking you to imagine the two different types of worlds and why it is that legislation such as POPI is actually necessary. Because if you take world number 2, which was a technology-ridden world, and you say on top of the technology, mayhem and madness, let's have no laws, no rules, no frameworks, and then what would happen? We would have identity theft, possibly lawlessness, and basically, to put it in easy English, everyone knows everything about everyone. And there's nobody to say, hang on a bit, that personal piece of information that you have on your client from his balance sheet, you need to put it in a safe place so that if your office is broken into, the thief doesn't have access to that information. And so, by juxtaposing these two worlds, I guess what I'm trying to do is to paint a story of the why behind the Protection of Personal Information Act. We need it precisely because a world without rules is a world of mayhem and a world of anarchy, and of course, none of us want to live in such a world. So, I guess my very first formal slide on the Protection of Personal Information Act is to do a little bit of retrospection. Why do we have this POPI Act and what does it aim to do? I went to the legislation and I have as you can see, about 7 objectives of the POPI Act. Firstly, the Act says in the actual legislation that it is there to promote the protection of personal information that is processed by public bodies and private bodies. So already we've learned something. POPI is not just applicable to private bodies. Then it is there to introduce certain conditions. Why do we need those conditions? Because there are minimum requirements that these public and private entities need to have in order to process. Now there's a verb you need to familiarize yourself with, because this Act is very clear that it's a processing of the information that's important. And we will double click into that word processing and unpack it a little bit further on. The third objective in the legislation, it says that it needs to provide for the establishment of this new entity, this new persona called the information regulator. Did you ever in your life think that one day we would have something such as an information regulator? Well, POPI is now bringing this new persona into being. What does this information regulator do, you may ask? Well, this information regulator is bestowed with certain powers by the legislation. Why? Because this regulator will have to perform certain duties and functions in terms of POPI. The fourth objective in the POPI Act in the introduction says it has to issue codes of conduct. Now, in the legislation, we will have a high-level overview of the do's and the don'ts, thou shalt and thou shalt not. In order to flesh out the detail behind the do's and the don'ts, or as I like to call it, the 10 commandments, we have subordinate legislation, we have codes of conduct, and we have regulations that kind of flesh out the detail behind what the intention and the spirit of the legislation intended. The fifth requirement and objective is to provide for the rights of persons regarding unsolicited electronic communications. Now let's stop here for a minute. How often have you found yourself in the middle of preparing dinner when the telephone rings or you receive an SMS saying, would you like to sell your house? Or, dear Advocate Apasamy, are you interested in purchasing one of our special offers at this ABC dealership? And you're thinking to yourself, really? At 7 o'clock in the evening, when these people should not be communicating with me? And so POPI then becomes your friend, because this unsolicited invasion of your privacy is strictly prohibited by POPI. And I think that's something that we as consumers can be really glad for. The other 2 last objectives of POPI from the legislation is to regulate the flow of personal information across the borders of the Republic. So if information leaves South Africa and goes to another jurisdiction and their privacy laws are not as restrictive or as comprehensive as ours, we should know and we should have confidence as consumers, as data subjects, that our information is going to lands and places where the information privacy legislation is similar or better than South Africa's. Finally, any matters connected with protecting privacy and personal information is what POPI aims to do. So I think that provides you with a nice summary from the legislation itself of the objectives. Now that we've looked at how POPI directly from the legislation describes its own objectives, let's try to look a little bit more into detail from an introductory perspective. So if POPI was a person and you had to meet it for the very first time, how would it introduce itself to you? So firstly, POPI sets out conditions regarding how personal information is A, collected, B, stored, C, used, D, disseminated, and E, deleted. So it's the whole lifespan of that information that's been collected, from the collection stage all the way until its death, until it's deleted. Now, the definition of the word personal information is fairly wide in the legislation, and I guess you can imagine why, given the second world that I painted to you with all the technology earlier. This includes information which identifies and relates to 2 types of persons. Number 1, natural persons. And natural persons would give out information for employment purposes, application to academic institutions, to hospitals, etc. And then corporates. And here we're talking about all the different types of business entities that one can possibly have, from partnerships to sole proprietorships to companies, to public companies, as well as to CCs. So these types of entities would give information such as company contact details to the bank for opening up a business account, and of course entering into a service level agreement with a prospective supplier to a business. They would want to know things about you. Anybody that wants to enter into a contract with you as a company, as a corporate, would want to know things about you. So personal information extends to these two types of persons, if you like, and in respect of all of the things that I've just described. So it has a fairly wide meaning. Now, there's a new term that the Act introduces that is specifically defined in the Act and is specifically catered for in the Act. And this persona is known as a data subject. Now, you are a data subject, I am a data subject, your spouse is a data subject. A data subject is a natural person or a juristic person that has information, i.e. data, that could be construed as personal. POPI protects personal information by imposing minimum standards in the thou shalt and thou shalt not, in how you could lawfully process this information, and we spoke about the life cycle of that earlier, from collection until deletion. You as the data subject must consent to the processing of personal information except in certain circumstances. And the most common of these circumstances is where the processing of the information is necessary to conclude or perform a contract with the data subject. Now, POPI is all about balance. And if you look at the picture that I've drawn here, we've got the scales of justice in the middle. On the left-hand side, we have the right to access information, which our constitution in South Africa, hailed as one of the strongest constitutions in the world, allows us to access. And here we have an act in South Africa, another act known as the Promotion of Access to Information Act. So that act allows relevant individuals, applicable individuals, to gain information, access to information. On the other hand, we have this protection of personal information, the POPI Act. And this is about the right to privacy of personal information. So you can see that on one hand, the Constitution is saying people with relevant reasons, good reason, good cause, may access certain information, and that's PIA, the Promotion of Access to Information Act. But on the same hand, it's saying, hang on a bit, we also need to protect the privacy of personal information. So you've got this balancing act that POPI and PIA are trying to achieve hand in hand. I've come up with the 4 W's of POPI. And the 4 W's are simply the why, the when, the what, and the who. So let's tackle W number 1, which is the why. In terms of our constitution, South Africans have a right to privacy, as I've just said. Now, major trading partners around the world subscribe to legislation which requires adequate protection of personal information. Now, can you imagine if South Africa wasn't aligned to the same standard of international privacy? We would not be able to trade with the rest of the world, because the rest of the world is going to say we're quite archaic in our privacy laws. So, apart from giving effect to the constitutional right to privacy, POPI's also got a good trade reason why South Africans should be compliant. The second W is when. Everybody's asking the question, if you Google effective date of POPI or date of commencement of POPI, you will get many law firms, you'll get many articles stating that at this particular point in time, it is unknown when the main sections of the legislation will come into effect. However, certain sections have already come into effect. So let me give you those examples. For example, the establishment of the information regulator. Remember, we spoke about this persona before. This particular piece of the legislation has already commenced. It's already given effect to. So that the minister and the regulator can now start introducing regulations. And the process to make these regulations is also being given effect to. So parts and pieces of POPI have commenced, if I can put it like that, and other parts, the main parts about when you will need to comply, have not yet commenced, have not yet taken effect, and we wait to hear when that date is going to be. And the experts are saying around the middle of 2015. So we're looking at Q3, Q4 of 2015. What we do know from the legislation is that there will be a grace period, and lawyers call it a transitional period, for about 12 months from the date that the commencement will occur until you have to actually comply. So you will have some time, but my advice is start thinking now about how you will be complying so that when your grace period happens, it's all about implementation. The third W in POPI is the what. What is the intention of POPI? And as I've stated before, the intention of POPI is largely to bring South Africans' data protection laws in line with international best practice. If we want to play in that space, we need to be on par. We need to have similar rules and similar standards. And then the last W in POPI is who must comply. So as I've said, public and private organizations, which means natural persons, individuals, there is no minimum threshold for compliance. So there's no rule in POPI that says if you're an organization with a turnover of 5 million or less, you don't need to comply. No, there's no such thing. All corporates, all companies, all businesses must comply, both public and private. It also applies to South African organizations which process personal information, including employees. So you might not be a hospital, you might not be a university, you might not be a school that processes personal information. However, you might be Joe Soap, Pty Limited down the road in your accounting practice who has 20 or 15 or 1 or 2 employees, and so therefore you are the custodian of their personal information. So you can see that the arch and the extent of this piece of legislation is overarching. We move on to what are the exemptions, if any, under the legislation. And POPI provides exemptions where the processing complies with legal obligations imposed by other laws. For example, if you have a regulator who's authorized to process personal information, and that in terms of another piece of legislation, and such processing is not in breach of POPI, then that will be a situation which is exempt from the provisions of the legislation. Also, when personal information is in the public interest, for example, in the interest of national security, the person that's got this information can't tell us, well, I'm protecting personal information, so I cannot divulge the information to you. Because if it's in the interest of all of our security, then surely it should be allowed to be revealed. Another instance is in the prevention, detection, and prosecution of offences. Can you imagine a court case? And I think of a famous one that happened not too long ago, where because of POPI, we would have possibly been unable to look at cell phone records. Now, of course, this is in the line of prosecution of a particular offence, and therefore POPI will, the particular court requesting the information will be exempt from POPI. And then when there's important economic and financial interests that are at stake, and lastly for historical, statistical or research activity. So you can see from these 4 exemptions that I've read out that it's not that POPI is there to stifle in the interest of the advancement of mankind. It is simply there to balance the access to private information, personal information. So we've seen the exemptions. We now move on to the who's who in POPI. Even POPI has a red carpet. And I've identified 4 basic characters, if you like, or personas, as I've referred to it previously. The first one is a data subject. I've already spoken about the data subject. This is officially the person to whom the information relates. So if you're talking about Jane's identity number, then I am the data subject. My identity number is being stored, or my identity number is being collected or deleted. I'm the data subject. Then the second persona is the responsible party. Now, the word responsible in the term responsible party is extremely important, because this could be a private body or a public body, as I've stated, or any other person determines the purpose of and means for processing personal information. So, a responsible party could be an accounting practice, it could be a hospital, it could be a university, it could be a massive law firm, it could be an insurance company that looks at underwriting records, for example. So a responsible party is any private or public body that is engaged in the business of processing personal information, if I can use my own definition. The third persona is an operator. An operator is a person who processes personal information for the responsible party. So, for example, you could have a data storage company called ABC Data Storage who stores data for you. And if they are doing any processing as defined, then they could well be an operator. You could have a person in your business who processes information for underwriting purposes or for balance sheet purposes or for the receiver of revenue purposes. That person is an operator that works for the responsible party. And the last persona is the regulator, and we've already spoken about the information regulator, established purely for the purposes of POPI. So that's the who's who. I now want to make a distinction, as does the legislation, between personal information, which I've been talking quite a bit about, versus special personal information. So it's kind of like Animal Farm. All animals are equal, but some are more equal than others. Here we have all information is special, and we have personal information, but special personal information is better than personal information. So the following are considered special personal information in terms of the Act. And why do we put special personal information on a podium? Because the requirements to process this information are way more onerous than just ordinary personal information. This is my own term, ordinary. So the personal information that is special are personal information relating to children under the age of 18, and you can imagine why minors need to be protected. And the second type of special personal information is information which includes private information relating to the following. Number 1, religious beliefs. Number 2, race. Number 3, trade union membership. Number 4, health. Number 5, sex life. Number 6, biometrics. And number 7, criminal offenses. I want to attach the term sensitive to the Act's terminology of special personal information, because your health or your sex life is sensitive information. Your race and your trade union membership is sensitive information. These pieces of information that are described as special by the legislation can open you up to all kinds of abuse. And so therefore, the Act prescribes that these special pieces of personal information must be way more carefully kept and managed and secured than ordinary personal information. Again, the word ordinary is my own term. So, if we just talk, I've just called out all the different types of special personal information. Now that we've spoken about sensitive or special personal information, let's turn our attention to regular or ordinary personal information. This is information as prescribed in the Act that relates to, number 1, an identifiable living natural person. Number 2, an identifiable existing juristic person, such as a company. Number 3, it is not about whether information is readily obtainable, but the focus is on the nature of the information. So the information could be buried deep down somewhere. It's the nature that's important, not the fact that it's easily obtainable. I think it's important to note that it's personal information and not only private information that is protected. A lot of people use the words interchangeably and they don't mean the same thing. And what I might consider private, for example, in terms of my value system, might not be what you consider private. So that's why the Act goes to great pains to describe what is personal information. So information relating to race, gender, sex, pregnancy, marital status, national, ethnic or social origin, color, sexual orientation, age, physical, mental health, well-being, disability, religion, conscience, belief, culture, birth are all personal information. Also information relating to the person's educational or medical history, background or status, financial status, criminal status or employment history is also personal information. So if you have an HR or a personnel department that does checks regularly on staff to see where they've worked before, have they got a criminal record, what is their financial status by doing one of those credit checks, doing one of those database checks in terms of does this person really have this qualification. This is all construed as personal information. That HR person needs to be educated in terms of how they manage and handle and save and delete and obtain that information. Personal information is also any identifying number, and I think I said ID number before, could be your student number, a symbol that symbolizes who you are, an email address, and most of us these days have more than one, a physical address where you live, a telephone number, a location information. For example, a particular piece of software identifying where you are simply by the use of a cell phone, and an online identifier or any other particular assigned to that person. The biometric information of the person is also considered personal information, and the personal opinions, views, or preferences, and I can think of a few social media websites that keep this information on your opinions, on your views, on your preferences based on your updates that you put into the system. Now, this is interesting. I think you'll find this very interesting, that personal information is also defined as the views or opinions of another individual about the person. It is also defined as correspondence sent by the person that is implicitly or explicitly of a private or confidential nature, or further correspondence that would reveal the contents of the original correspondence. Note, correspondence can be a WhatsApp message, a BBM message, it can be a text in your phone. Personal information is also the name of the person if it appears with other personal information relating to the person, or if the disclosure of the name in itself would reveal information about the person. So when I told you that the definition of personal information is wide, I was not exaggerating. I'm sure you'll agree with me. And that brings us to the end of what is personal information. I'm now going to move on to, and I've described the differences between the two earlier, special personal information. And special personal information is defined because it needs more care, more protection, more onerous requirements. And let's start with what describes personal information that is special. Number one, your religious or your political beliefs. Number two, your race or your ethnic origin. Number three, your trade union membership, your political persuasion, your health or sex life, your biometric information, your criminal behavior is special personal information. Now, who would collect, let's go through this very quickly, religious or philosophical beliefs. Your church, your temple, your synagogue will contain information about data subjects belonging to these organizations. This information, it is very important for you to know, may not be supplied to third parties without the data subject's consent. So your religious affiliation to an organization means that they have special personal information about you, and they may not divulge your details, your personal information, without your consent. If we go to race or ethnic origin, why would you want to know about a person's race? Well, very simply, sometimes it's essential, and I think of a census in this particular example. So if our country is busy with a census exercise, they want to know how many people of a particular race or ethnicity exists in South Africa at a particular point in time, then they're going to ask you for your race or your ethnic origin. Trade union membership. Why would this be special information? Because this type of information is necessary for a trade union to have. The data subject belongs to the trade union, and the processing of this information is necessary to achieve the objectives of the trade union. But you might not want everybody to know which trade union you belong to in particular, or for your trade union to share your personal information. I've just thought of another very pertinent reason. I'm going to jump back to race or ethnic origin. Broad-based black economic empowerment defines certain members of our society on racial grounds and even on ethnic grounds. And these particular people will belong to organizations who have to keep statistics of how many Africans, how many Indians, how many coloreds, how many Chinese, how many white staff we have, for example. So for reporting purpose, for statistical purpose, for employment equity purposes, BEE purposes, we need special personal information. So we can see why these types of information are divulged, because of legal reasons sometimes. Then you may ask your political persuasion. So here you have a particular institution that is founded on certain political principles, and they need to process information in order to achieve their aims or objectives. Once again, like we discussed with the church or the synagogue, this information may not be supplied to third parties without your consent if you belong to this political party. Then health or sex life. Here you have medical practitioners who will ask you questions, particularly in the era that we live in with HIV and AIDS and rights that we have in South Africa that have been conferred to same-sex marriages, for example. So you might have a healthcare institution or an insurance company that's asking you about your health for underwriting purposes. Medical aid scheme providers, they will ask you about your health conditions. Do you suffer from a chronic condition? Is considered special personal information. Schools will ask you, and any public body will also ask you for special personal information relating to your health. Now, if you belong to a pension fund and employers are processing information, they will also ask you personal information relating to information that will further the objectives of the pension fund. Once again, the processing has to be confidential, and that particular organization, that pension fund or that employer may not divulge your personal information without your consent. So you can kind of see the pattern and the trend. And that brings us to the end of what is personal information and what is special personal information. Now we move on to processing as defined in the Act. Because remember this, information, there's a data subject about whom the information is collected, stored, retrieved, deleted. There's the information regulator, as we discussed before. And now you've got a data subject, you've got personal information, or you've got special personal information, and of course you're processing. That's the verb to the actual noun, the personal information. So what is processing? Processing is referred to in the Act as any activity concerning personal information and may include, number one, the collection, the receipt, the recording, the organization, the collation, the storage, the updating, the modification, the retrieval, the alteration, the consultation, or use of personal information. Very wide. Number two, processing of personal information may also include dissemination of that information by means of transmission, i.e. emailing that information to someone, or if you still fax, faxing that information, or scanning the information and making it available on a public site. Distributing that information or making it available in any other form. So if you copy and paste the ID copy of someone and put it in a public forum or put it on an email, that is what this is talking about, disseminating. Number two, processing also refers to dissemination by means of transmission. For example, sending the copy of an ID via email. The distribution of that or making it available in any other form. So having a paper-based copy of somebody's proof of address, scanning it, emailing it, putting it on your website, that's what this particular part is talking about. That's also processing. And thirdly, processing is merging, linking, restricting, degrading, erasing, or destructing of the information. So it's not just collecting the information and doing something with it, it's also how you dispose of the information. So processing is quite wide in its application, as we saw with personal information being wide in its application. I would like to talk about processing of an employee's information in particular, because I'm sure that most of us in the world of business, in any organization, will be processing employees' information. This is defined as any activity that you perform on personal information, and they include, for example, collecting, recording, and destroying the information of an employee. Now, it is only the processing activities of personal information that is entered into a record, in inverted commas, by or on behalf of a responsible party, and we discussed responsible party earlier, and that responsible party must be domiciled in South Africa, or if it's not domiciled in South Africa, that responsible party must be someone who is using automated or non-automated means that are situated in South Africa, unless that automated or non-automated means is only used to forward personal information through the Republic. Now, what does this mean? This is restricting the realm around which POPI operates. So it's saying that when you're involved in processing activities of personal information, and that is entered into a record, and you are a responsible party that's either domiciled in South Africa, or if you're not domiciled in South Africa, you use automated or non-automated means that are situated in South Africa. So you might be operating a call center in South Africa from America. That's what that second part is referring to. And because the automated means of operating the call center, i.e. in South Africa, is based in South Africa, then POPI will apply to you. So you're not domiciled in South Africa, but you have a call center in South Africa, and that call center of you being the responsible party, even though you're located outside South Africa, is then subject to the rules of POPI. And I think that's fundamental for multinational corporations who operate part or some of their business in South Africa, but for the main part, they are outside of South Africa. They are still subject to POPI. That's important to know. So what constitutes a record? Any recorded information, this is the definition, in possession or control of the responsible party, regardless of the medium, so it can be paper-based, electronic, and regardless of when it came to existence. Any label, any marking, or any other writing that identifies or describes anything, so a signature could be described as a record, a thumbprint could be described as a record, because it refers to a marking. Books, maps, plans, graphs, drawings are all falling within the realm of a record. So that brings us to the end of what is a record. Now we move on to the data subject and what are your rights as a data subject. And we are all data subjects. To know if an organization holds personal about them free of charge. So if you pick up the phone to ABC Pty Limited and say, hello, my name is Joe Soap, this is my identity number, do you have any information regarding me, any personal information? That company is obliged to provide you with a yes or a no and details free of charge. Make sense? Then, data subject rights number 2, to access that information for a fee. So if that organization says, yes, Joe Soap, we do have information regarding your medical conditions in my story, you can say, may I have a copy of that record, but that organization is entitled you to charge you a reasonable fee for the processing of providing you with that information. Data subjects rights number 3. You may request correction or deletion of inaccurate, irrelevant, excessive, outdated, incomplete, misleading, or unlawfully obtained personal information. Let's use an example. You're Joe Soap, you phoned up ABC Pty Limited to ask them, free of charge, do you have personal information about me? They said yes. You then pay them a fee of, I'm using an example now, 50 Rand to access that information. Now we move on to your right number 3. You read through this information and you see, hang on a bit, it contains the fact that I had hay fever when I was 5 years old. I'm now 55. Completely outdated. Or, this information was unlawfully obtained by ABC Pty Limited. How come they have my medical information? Or, this information can be misleading because it says I could potentially have eczema, or I could potentially have an allergy to nuts. Could be misleading. It's excessive. Now you could argue that with ABC Pty Limited, and you could say to them, I want you to either correct this information, I want you to delete this information, etc., etc. That's what this right number 3 is saying in a story. Data subject right number 4. You as a data subject have the right to request destruction or deletion of personal information that an organization holds on you that is no longer authorized to retain. Let me give you an example. If I am a member of a medical aid, the time during which I'm a member of the medical aid, it's reasonable that this organization should hold my personal information. However, once I terminate my medical aid membership and I'm no longer with that medical aid, perhaps they might be entitled to retain certain bits of personal information, but not all. So I have the right to call up that medical aid and say, number 1, to go back to your rights, do you hold my personal information free of charge? You need to tell me yes or no. Number 2, at a fee, may I access that information? Number 3, I now read through the information and I need you to delete inaccurate things or excessive things. Number 4, I can say to you, now that I'm no longer a member of your medical aid, you only need to keep my membership date, my chronic illness for purposes of legislation, for example. You don't need to keep anything else. You don't need to keep X, Y, and Z. So provided that that organization that is holding the data subject's information is not obliged by law or by any other legitimate reasons to hold that information, then the data subject can say, please get rid of this information. I'm not your member anymore. You don't need to keep this personal information about me. So it's important to know those 4 data subjects' rights, because when you, in your practice, are approached by a client to say to you, you used to be my accountant, you used to be my lawyer, you used to be my bookkeeper, you used to be my medical practitioner, and now that I'm no longer requiring your services, you may not keep this information any longer. You need to be aware of what those data subjects' rights are. Now that we know what a data subject's rights are, let's move into another aspect of the legislation. And this is very, very close and dear to many of your hearts, I'm sure. This is about you being contacted as a prospective client. Or, if we flip the situation around, you contacting a prospective client that has been referred to you. What are the rules here? So listen up. Number 1, you may not contact a prospective client through automated calls, emails, or SMS to promote any products or services unless A, you have that individual's informed consent, and you give the prospective customer the opportunity to opt in to specific use. So you may not just make contact with somebody unless you have their consent or you contact them for their consent and they can opt in. Number 2, all communication must contain the organization's identity. So in other words, it must be transparent. Who you are, where you're from, why you're calling, your contact details so that they can phone you to say what they need to say. And the customer must be able to opt out at a later stage. So with regards to contacting a prospective client, you've got to remember number 1, the opting in, and number 2, the opting out. It will be essential for prospects and customers to agree to receive your communication. You'll find that many of the SMSs you receive these days or other means of communication will always have an unsubscribe button or an opt out or click 1 or press 1 if you don't want to receive this communication anymore. You must give data subjects that opportunity, and as a data subject yourself watching this right now, you must be given that opportunity, and this is critical. I think this is going to change the way a lot of direct marketers operate. So that's the end of how to contact a prospective client. I want to talk about another persona that's going to be in your business once POPI takes effect, if you are an organization that will be subjected to POPI. And this person is known as an information officer. Now, this information officer must be somebody who is attracted to responsibility because it is a responsible position. So who is this responsible information officer that I'm talking about? The information officer is the person at the head of a private organization or a public body or someone appointed by the head. So it can be you as the main principal person in your practice or in your business or in your organization, or it can be somebody that you appoint. This information officer must be registered, this is number 2, with the information regulator established under POPI before they begin to perform their duties. So number 1, it can be you or someone you appoint. Number 2, must be registered with the information regulator. So what will the information regulator have? A list of all the information officers of all the responsible bodies in the country. Number 3, what are the duties of this information officer? Must ensure compliance with POPI through training, through awareness, through sensitization, through information sharing. Must assist the regulator with investigations. So the regulator will see that Joe Soap is the information officer of ABC, Pty Limited. Will contact Joe Soap and say, Joe, we have a complaint from a customer, Tandi, about your product or about the fact that you sold your product rather to her without asking for her permission, or you tried to sell. You contacted her without your permission. Please, can you tell me what are your processes in terms of POPI, it's how you comply, etc., etc. So that information officer becomes a point of contact between the organization and the information regulator, and is a critical position. And the last point on the information officer is that employees may be designated as deputy information officers to assist. So you could have an organization who's a responsible party at the top, the information officer who's the head or an appointee registered with the information regulator, and underneath the information officer you might have branches around the country, and you might put a deputy information officer to be at the coalface of what's happening, your eyes and ears on the ground if you are the information officer. And I think this makes sense. Now that we know the what, when, why and how of an information officer, let's move on to another section. And that is informing the data subject if there is a breach with regard to any of the provisions in POPI. And this is extremely important. Imagine if your medical status, you have a disease that you don't necessarily want anyone else to know about because of possible stigmatization, and this information leaks in a hospital or in your little town that you live. Wouldn't you want to know so that you can prepare yourself to manage people's responses? I would. So POPI is quite in tune with this, and POPI says that when a data subject's personal information has been compromised, i.e. it is leaked, or the offices have been broken into and it's been stolen, or anything of that nature, or there's a disgruntled employee in your office, for example, that wants to damage your reputation as a firm and takes personal information regarding balance sheet information, annual financial statements of your clients, and sells it to the local newspaper, some unethical reporter, and off the disgruntled employee goes. And then you suddenly are aware of this. So what do you need to do as a responsible body? Number one, you must inform the regulator. So obviously it will be your information officer that will inform the information regulator. And identifiable data subjects where there are reasonable grounds to believe that this information has been accessed or acquired by an unauthorized person. Now, why does the Act say identifiable data subjects? Because it could be that this disgruntled employee disappeared with 100 files, and you could only identify from your knowledge and from your records 80 of the 100. So whoever you can identify, you need to make that call, do that email, call that meeting and say, data subjects, your information has been leaked via our office, and you have to inform the regulator as well. So if the regulator is approached by any of these data subjects 10 years from now, 5 years from now, to say this happened at this particular organization, you are able to say, but Mr. Information Regulator or Ms. Information Regulator, I advised you when this leak happened. And I'm just using my own terminology. So I'm sure from the scenario that I've just painted, you can imagine that it must be really important, firstly to tell the regulator, and then to tell the identifiable data subject when there has been a breach of the data. The second one is that the regulator may direct that a data breach be publicized if there are reasonable grounds to believe that publicity would protect a data subject who might be affected. Let me give you an example. Let's say a particular pension fund has got 500,000 members on its database, and that pension fund database has been hacked, and this hacker has taken personal information, special personal information about these 500,000 members and put it in the public domain, or sold this information to your competitor, and you get wind of this. So remember what you have to do. Number one, you must tell the regulator, or your information officer must tell the regulator, preferably in writing so that it's on record. And then number two, you need to inform the identifiable data subjects. But now the regulator takes a decision to say there are 500,000 individuals who are affected by this. You cannot get to 500,000 individuals quickly. So I'm going to make a ruling that this must be publicized. So either to put it in the newspaper or on a website or in the local newspaper to say these members have been, information has been sent out, has been leaked. They must please contact this company because this pension fund information has been hacked and therefore they must take the necessary steps. So we see here that the regulator has rights to order a public announcement, if you like, of the leak or of the data processing requirements in POPI being breached. And that's important for you to know. So that brings us to the end of what to do when information is dealt with in a manner contrary to what POPI dictates. We now move on to what is not covered by POPI. And I think this is important because we've been going on about who is the regulator, who is the information officer, what must you do when the information processing has been breached in terms of POPI. Now we want to look at a very different piece of information, and that is what is not covered by POPI. So pure household activities are not covered by POPI. A household is not an accountable institution or a responsible organization. Information that has been de-identified, meaning that information that identifies a particular person has been deleted. So I'm busy with my master's in entrepreneurship. I'm busy with some research with entrepreneurs on the side of the road, and I take their name and their number and their information, and then I come up with statistics that say 70% of entrepreneurs on the side of the road are necessity entrepreneurs. Now I've taken information of 100 entrepreneurs, I've de-identified the people, so I'm not saying person X, person Y or person Z, it's merely some kind of statistical data that I am compiling, and I have taken out the personal information out of that statistic, and that's allowed. And so POPI does not cover that. Number 3, information by or on behalf of a public body which involves national security, defense or public safety, and we've discussed this before. So if it's in the interest of national security, POPI is not going to cover that particular information being processed. And number 4, processing for purely journalistic purposes by responsible parties who are subject by virtue of their office, like newspapers, news channels, employment or profession, to a code of ethics that provide adequate safeguards for the protection of personal information. So if I belong to a particular news channel and I am processing personal information, but I'm also governed by the laws of the land where I operate in my journalistic world, then it will not be covered by POPI because there is already a standard applicable to those professionals. And by virtue of what they do and by the very nature of what they do and the ethical standards to which they are bound, they will be processing this information for journalistic purposes. So journalistic purpose processing of information is specifically excluded. Good day and welcome to Part 2 of the Protection of Personal Information Act. As you will recall, in Part 1 we looked at the what of the legislation. We are going to look in this particular session at the how of the legislation. Do you remember in Part 1 I said if POPI were a person and it could speak, this is what it would say, and this is what it would look like, and this is what it would smell like? I'm now going to paint the picture of if POPI were to live in the perfect environment, what would that perfect environment be like? What would be a conducive environment for a healthy protection of personal information situation to exist? We're going to kick off with the processing condition that the Act prescribes needs to be in place by the responsible party in order to ensure that all is fine from a POPI perspective. Now there are 8 what I call pillars in POPI. There's the pillar of accountability, and that particular condition and that particular culture must exist in an organization to be POPI friendly. There's the processing limitation pillar, purpose specification, further processing limitation, information quality, openness, security safeguards, and data subject participation. Let's look at pillar number 1 in terms of context, and that is accountability. the responsible party, i.e. your organization, who process the personal information of your data subjects or clients, must ensure that all of the Act's principles and measures are complied with. Now, this accountability condition is really important because as the head of the organization, if you're watching right now, your responsibility as a leader is to almost preach the POPI gospel, but from a personal perspective. To switch it around and say to your staff, if your personal information, such as your medical condition or your sexual orientation, were to be published on the news this evening, how would you feel about that? So we almost need to sell the accountability aspect of this requirement by flipping it around and saying to people, if you were the data subject, what would you want to happen to this piece of personal information? And I think that really would instill a sense of accountability in people, because suddenly they won't be seeing themselves versus the customer. It will become a case of, what if I were the customer? This principle of accountability and culture of accountability is extremely important. Number 2, processing limitation is another requirement in the legislation from a condition perspective. And the processing of the information has to be lawful. It must be done in a reasonable manner that does not infringe the privacy of the data subject, and it must be adequate, relevant, and not excessive given the purpose. So if you are an accounting practice and you have Joe Soap's bank statement from ABC Bank, and the purpose of receiving those bank statements is to check how much interest he's earned in order to be able to calculate whether he has hit the threshold of the interest exemption or he's gone beyond the threshold, then that is what you need to look at on the document. You do not need to look at how many unpaid debit orders he has so that you can create and form a personal opinion about Joe Soap. You do not need to look at the fact that he has purchased a certain item with his debit card from a certain store that you might scorn upon. That is not the purpose of why you have his bank statement. So I think that story very nicely illustrates the adequacy, relevance, and excessiveness given the purpose that you have the information for. Pillar number 3 is that there's a condition that there has to be purpose in terms of the collection and the processing of this information. Personal information must only be collected for a specific purpose. So, for example, why would a bank want a copy of your medical record? Or, for that matter, why would a hospital want a copy of your bank statements? Unless they can prove the purpose and the link. The data subject must be aware of what the purpose is. And if not, the data subject can ask, why do you need my bank statement if you are a hospital? Records must not be kept for longer than necessary to achieve the purpose for which it was collected. So, for example, if I am pursuing a degree at a university and they require my information, I provide it to them, I complete the degree, and 10 years later, they are still storing my private information and using it for whatever purposes, it would be a little bit suspect, because the purpose for which my matric certificate and my identity document was collected in the first place was to establish eligibility into the university. And perhaps they might have wanted to keep the information whilst I was a student. But 10 years later, why would they want to still keep the information? Now, I'm sure you'll agree with me that there must be hundreds, if not thousands of organizations out there who are keeping old information, stale information, outdated information, which could be stolen, which could be leaked, which could go into the wrong hands. And of course, as you can imagine, this could prove to be very detrimental to the privacy of the data subjects. So I think this particular pillar of specification is really important. It's a fit for purpose personal information to be kept by the responsible party about the data subject. If it's not fit for purpose, you shouldn't be keeping it. Should we move on? The next pillar, number 4, is further processing limitation. So, sometimes we process data and then we further process data. Further processing must be compatible again with the purpose for which it was collected. So if information was originally collected for a specific purpose and then it is further processed a few years or months later or weeks later, for another purpose, that purpose must also be made known to the data subject, and it must be properly assessed. There has to be a relationship between the purpose of the first processing and the further processing. The manner in which the information is collected must be made clear, and any contractual rights between the parties must also be made clear. So you can see that the context for a healthy POPI atmosphere and environment doesn't only relate to processing, it also relates to what happens with further processing. Pillar number 5. The context must be ripe for quality information. The responsible party must take reasonable and practical steps to ensure the following about the information. Number 1, that it is complete. So if I've said half a sentence in my declaration under oath, and I don't have the opportunity to explain why in the other half of the sentence, or it's cut off, or it's 1 page out of 2-page documents that are being saved, the information is incomplete. And it might create a misapprehension or a misconception in the mind of the reader who only sees the 1 page. Also under information quality, the information must be accurate. So my ID number must not be stated as the last digit being incorrect. I recall personally that I once had an invoice from an ambulance service, and to this day I've never been in an ambulance where I was the sick person, the patient, and I received an invoice. I was very amused, and what they did was exactly this. They had personal information about this other person who had a similar ID number to mine, but one of the digits was entered incorrectly. And then the onus was on me to prove to this credit bureau that actually I was never on the ambulance. I've never been in an ambulance as a patient. So this is critical, that the information is accurate, because you might end up being a data subject that's being incorrectly accused of not paying a bill or any such thing. Then the information quality must not be misleading. In other words, like we discussed with incomplete documents, it mustn't lead the reader of the information to believe something else when the truth is far from that. And last but not least, the information quality must be updated. Can you imagine an outdated underwriting assessment from when you were 20 years old and you've now outgrown this particular condition, and you're 50 years old and you're sitting in a hospital and somebody pulls out an outdated childhood medical history that has got no relevance to your current state because you've outgrown the allergy, for example. All the while this quality information is being processed in this perfect POPI environment that I'm describing, we need to take into account the purpose for which the information was initially collected. And the data subject needs to be made aware of the purpose for which the information is initially collected. The next pillar, which is pillar number 6, talks about openness. Responsible parties must take reasonable steps to ensure that the data subject is aware of the information being collected, so there must be transparency, there must be openness and disclosure. So I must know if somebody is using a copy of my ID to keep a record of me because I'm alumni at that particular university. The purpose for which the information is collected must also be divulged, as we discussed under purpose. So you can see openness and purpose, the two pillars are talking to each other. Also under openness, whether supply of information is voluntary or mandatory, you have to tell the data subject that. So for example, when you apply for an insurance policy, and they ask you to go for a medical, which is a blood test to determine your HIV status, they have to tell you beforehand that it's mandatory for you to have an HIV assessment before we give you insurance, because it determines a level of risk, and therefore we may not insure you, or we may load your policy, etc., your premium. So it's really important that when you ask for personal information, the data subject knows this is voluntary, but this is obligatory. You have to provide it. The next one under openness is consequences of failure to provide information. So for example, if I am applying to an overseas university for a PhD and they need to know my medical status because that country is very particular about bringing in students from Africa, then they need to tell me that if you fail to So let's reverse that. Let's say it's a South African university, because POPI applies here, that is asking for medical information about a student in South Africa coming to South Africa to study from a country where health risks are widely known to occur. So there, the South African university has got to tell the data subject, if you fail to provide your medical history or your medical condition or the vaccinations that you've taken, then the consequences are that you may not make the pile to make it into our PhD. So that is an example of informing the data subject of the consequences of not providing. Because you don't want the data subject to be disadvantaged because you didn't supply the reason for wanting the data, the personal information, and what are the consequences of the data subject not providing the personal information. And that's the principle of fairness, I think, on both sides. And then lastly, any particular law that applies. So for example, if you as an organization are doing a FICA check on a client because you happen to be a bank and it's required by law, then you need to say to the client, ma'am, we need proof of identity, we need, or sir, we need proof of address, etc., etc. The reason we need this is because of a piece of legislation known as the Financial Intelligence Center Act. So you need to be open and transparent about why you're asking for the personal information if there's a legislative reason for you asking for it. For example, if you're asking somebody for their race in a place of employment and it's for BEE statistics purposes, then you've got to state that. And that is the principle of openness, which I believe is quite an all-encompassing, pervasive principle that applies throughout the legislation. Pillar number 7 is security safeguards. Now, this is where the IT guy with the lock in his hand pitches up. If you keep a lot of electronic data, or the lady with the keys to the good old-fashioned filing cabinets, those steel ones, the lady who keeps the key. This is the part where she pitches up, because this talks about the fact that you as the responsible party must ensure that the integrity and the confidentiality of personal information is in place. How do you do this? You take appropriate, reasonable, technical and organizational measures. Now let's talk about what that means in non-legalese terms. If you have a filing cabinet and you're keeping paper-based documentation, then make sure that it's personal information and it's information that shouldn't be damaged, etc. Make sure that it's an appropriate cabinet, it's in a locked office, or it's in a safe place. There's a reasonable amount of access to the keys for that particular cabinet. Now let's talk electronic, because this is kind of where most of us are these days. So if you're storing information on your laptop, personal information. So if you're a financial advisor and you have personal information, or if you're an accountant and you have personal information, or if you're a legal person and you have personal information about your client, make sure that A, you password protect your computer. B, you do not leave your laptop lying around in public places where it can be easily stolen. C, your password is not something like password 1, which is quite common. D, that you take all reasonable precautions that are appropriate in order to ensure that that personal information on the computer is as well guarded as if it was your own personal information. That's what security safeguards is saying in a nutshell. Now, in the event of security breaches, as we discussed before in session number 1, the responsible party has got to notify the regulator, has got to tell the regulator, this is what happened, my laptop was stolen and I had 500 IDs on it because I happen to be an accountant and I do the personal income tax returns for my clients. I beg your pardon, you also have to notify the data subject. Pick up the phone the 500 clients, send them an email, send them a message to say, I'm so sorry, I was at the airport, I locked the laptop in the boot of my car, and when I got back, my vehicle was stolen. That computer, if it's tampered with, if the password is hacked through, your identity document is on that computer. So this is the extent of security safeguards. And I would rather err on the side of caution if I were you, and I would rather let the data subject, i.e. the client, know that the laptop was stolen, rather than assume that, the hacker's never, or the thief is never going to get into my computer because my password is so difficult. So that if something happens in the future that they can trace back to this event, you've covered your bases, you're compliant because you've notified the regulator, you've notified the data subject, and you've fulfilled your obligations. The 8th pillar has got to do with this beautiful word called participation. And what it's saying here is that from a data subject's rights point of view, they can request from you, the responsible party, whether information is held. Remember, we covered this in session 1, and it's actually part of the pillars. Number 2, they can request a description or record of the information at a prescribed fee if you have a fee. So you need to decide if somebody asks you for a copy of a piece of information that you've got to go to a data storage company to get, and get somebody in your organization to email it to them, how much time is it going to take and what is it worth, and put a reasonable cost to that. And then perhaps, if I were you, have a list of what you would charge clients for different pieces of data depending on what it would potentially cost you. So that if you are requested this information, you already know you've got a calculated amount based on an informed decision that you made about how much to charge the data subject. Then the data subject participation pillar also talks about request confirmation of recipients, and responsible party may refuse data subject to certain information on the basis of grounds in PAIA. Now, let's talk about that for a minute. In session 1, I showed you the lovely picture of the scales of justice, and we put the Protection of Personal Information on one side, and we put the Promotion of Access to Information Act on the other side, and we said it's all about balance. It's about accessing information if it really has to be accessed and it's appropriate and it's relevant and it's important, and then we said maintaining privacy of data, and how do you balance the two. And what this particular requirement is saying in this pillar about data subject participation is that the responsible party, i.e. your firm, may refuse data subject to certain information because, for example, the Promotion of Access to Information Act may apply. So let me give you a typical example. If you are an accountant and you know the confidential, personal, financial information about me, and there is a party with a vested interest in understanding what my financial situation is because I've misrepresented it to them, and they approach you or your information officer on the basis of the Promotion of Access to Information Act, if the Promotion of Access to Information Act allows you to do that, then you must do that. In other words, you've got to say to your subject, your data subject, I cannot refuse giving person X this information because they have raised the issue that PAIA allows them, the Promotion of Access to Information Act allows them. So we can see that you also will need to balance and understand that PAIA is still operating, the Promotion of Access to Information Act is still operating in a POPI environment. So your POPI environment has got to be PAIA friendly as well, because both pieces of legislation need to be given effect to. That brings us to the end of the 8 pillars. I hope you enjoyed the little stories and the scenarios that were shared, and that it made it a little bit more real for you and took away a lot of the legalese and the English that often confuses us in drafting legislation. Now that we've looked at the 8 pillars, as I call them, or the 8 conditions that need to exist in a POPI-friendly environment, let's turn our attention to, now that you know, what are you going to do with it? In other words, what should you start doing now? If you look at the slide, you will see that from a compliance perspective, there are laws that you have to consider. We've discussed PAIA, the Promotion of Access to Information Act, which allows access, and then POPI, the Protection of Personal Information Act, which kind of closes access to an extent. And you're going to have to look at policies within your organization. How do I align my HR policy? How do I align my remuneration policy to ensure that confidential information and personal information, such as salaries, are protected and kept behind closed doors when it needs to be, and only relevant people have fit for purpose have access to this information. Then from a process point of view, now that I've got the policies in place to comply with the laws, how do I build processes that map out the physical actions that align to these policies? So from a compliance point of view, you've got guidelines, you've got regulations, you've got laws, and then of course you need to put policies and processes in place. So let's take a look at what it is that you should start doing, and not waiting for the commencement date to be announced, but start doing now so that you can put measures in place and you can ensure that your POPI compliance is in check. I thought before we started with the actual compliance steps, we should look at what are the consequences of not complying, because that might provide a little bit of motivation, don't you think? So number one, the data subject may lodge a complaint with the regulator if you don't comply. So remember the example of the university student who went back after 10 years and the university still had information about her even though they shouldn't? That university student, that graduate, can now go to the regulator and say, "Dear Mr. Information Regulator or Ms. Information Regulator, XYZ University has still got a record of mine and it's not current, it's not relevant, it's not fit for purpose. I don't go there anymore, I don't intend to return to that university, and they are not complying." So you could have a complaint lodged against you, which is not a nice thing. Then the regulator, number two, may try and secure settlement if there is a settlement applicable to that particular scenario. If no settlement is possible, then the regulator may initiate an investigation against you. Again, that's not a very nice experience to undergo, where the regulator is investigating your business. Both from a reputational perspective, from a regulatory perspective, it's just not a pleasant experience. If you are in breach, the regulator may issue an enforcement notice as per the enforcement regulations in POPI. And then the data subject or the regulator could also sue the responsible party for damages. So there's a possibility that there could be litigation. And of course, none of the stuff that I've just spoken about is pleasant when it comes to non-compliance. So what is my motivation for putting this slide up before I get to how you can become compliant? Is to simply say to you, it's just not worth it. You know what you have to do, you can make up a list, and you can start to do them one by one as soon as possible, rather than face these non-compliance consequences that we've just discussed. Moving on to more consequences of non-compliance, the court would be entitled to award if, for example, as we discussed previously, the data subject or the information regulator decided to sue the responsible party for damages. The court would be entitled to award damages to the aggrieved party, aggravated damages, interest, legal fees. You really don't want to be saddled with all of this financial burden from the court order. For example, if a data subject suffers any loss as a result of an infringement of POPI, the responsible person will be strictly liable for this loss. So let's say, for example, a religious institution that you belong to had information regarding your sexual orientation, and you went for a job interview and the information leaked contra to POPI requirements from the religious institution into your community, and somebody who works at that organization where you went for an interview happens to work in that organization and live in that community where the information was leaked into, and then you end up not getting the job because your sexual orientation was divulged, something that was confidential and private and personal, that remained with the religious institution and was unlawfully leaked from the institution. So now there's some financial damages that one can start talking about, because if you're unemployed, then you need to sustain yourself, and perhaps you might have gotten the job had this unlawful thing not happened. So therefore, the responsible person then must take the liability for this loss, and in this case it would be the religious institution. They would be the responsible party because they allowed, through their negligence or whatever, or intention, for the loss to happen through the leakage. It does not matter if the responsible person was negligent, I think this is important for you to know, or if the responsible person acted intentionally when this POPI infringement happened. So it could be that the religious institution forgot to lock the doors of the office and somebody came in, saw the information, and it leaked into the community, it leaked to this potential employer, you didn't get the job. Or it could be that the religious institution intentionally leaked the information regarding your sexual orientation for whatever reason. So it doesn't matter in the eyes of this particular piece of legislation whether it was intentional from the responsible party or negligent. If the infringement caused loss to the data subject, to the consumer, to you in this case that was affected negatively, then the responsible person is liable. I think this is really, really important for you to know as an organization, and for you when you're talking about accountability, if we go back to that pillar number 1, to tell your staff that if we have an infringement of POPI in this office, whether it was negligent or whether it was intentional, we are still responsible as the responsible party. This company is still responsible. And because you work here, you will be held responsible in the company's eyes. And I think that's important. And this ties in pretty much with accountability. So now we know what the consequences of non-compliance are. Let's look at actual rands and cents, shall we? We're now moving to this next slide, which is showing on your screen, that's called offenses and penalties. Now, obstructing or unlawfully influencing the regulator is stated as an offense. Breach by persons acting for the regulator of duty of confidentiality is an offense. Failure to comply with an enforcement notice is an offense. Making false statements is an offense, and so on and so forth. Now, from a non-compliance point of view, I know we've talked very high level, but if you look at the slide, it says there may be civil action for damages, enforcement action by the regulator, criminal action for any offense committed. So you can see that this is very, very far-reaching. It's not just about paying 100,000 Rand fine, but it could also lead to criminal sanction. So what are the penalties? And it all depends on the severity. Up to 10 years imprisonment, fine, or you could get both. Up to 12 months imprisonment, a fine, or you could get both. And again, it depends on the severity. So the more severe the impact of the negligent or intentional leak of the personal information, the more severe impact it has on a person, like losing your job versus losing your arm, or losing your job versus losing your reputation, whatever you consider to be more severe, then you will obviously have a higher imprisonment term and a higher fine, or both. And then there's a note that the regulator may issue an administrative fine of up to 10 million Rand for an offence. And that's quite a significant amount. I'm sure you'll agree with me. There are two important points now that we've looked at non-compliance and we've looked at penalties. If you process information such as names, addresses, email addresses, ID numbers, employment history, health data that are associated with an individual, juristic or natural person, even if you outsource the data collection or data retrieval or data custodianship to a third party, your company, being the responsible party, will have to comply with POPI. So let's use an example. Let's say you use a company called Neat as a Pin to store your data. And Neat as a Pin comes to your offices every day, they collect it, or every week, they collect a bunch of files. Neat as a Pin go back to their offices, they scan the data, they responsibly destroy the paper, they shred it, and they get rid of it in a way that you can't reconstruct the information. And they store the data for you, and then when you need the data, you contact Neat as a Pin and they say, sure, we're sending you the information, and their turnaround time is 12 hours. One day, Neat as a Pin is broken into, and they haven't got password protected computers. And the thief has access to all your information of your clients that you've handed over safekeeping for to Neat as a Pin from a data storage point of view. And this information is leaked all over the Sunday newspapers. Let's do a quick quiz, shall we? While you're busy watching, who do you think is going to be held responsible? Neat as a Pin or your organization? So what this important point is saying on the slide is that even if you outsource your data collection, your data storage, your data retrieval to a third party, such as a company called My Make Believe Neat as a Pin, your company is the one that will be held responsible. And I think that's pretty critical. And you see a lot of other pieces of legislation also going in this direction. where you have to keep records for 5 years, for example, but if you outsource it to a third party, that third party has got the same obligations of 5 years as you did, and you are ultimately responsible for the safekeeping of the documentation. So other pieces of legislation are also saying that accountability means that the buck stops with you. Accountability does not mean that you can give that over to somebody else. You can never delegate accountability. You are accountable. You can delegate responsibility for keeping something, but not the ultimate accountability for keeping it safe. All organizations have personal information about shareholders, employees, customers, suppliers. So POPI affects every area of your business. I think this is a second key point on this slide called 2 important points. The first key point was that when you outsource, you are still accountable. The second key point is POPI affects every area of your business. I have a name for this principle. I call it the OROS principle. When you pour OROS into a glass of water, you don't get parts of the water orange and parts of the water still clear. All of the water turns orange. And so the OROS principle simply states that when a piece of legislation is pervasive, when it enters every single division, department, team within your business, then you really have to sit up and take notice because it affects everybody, almost. So, now that we know what we know, what questions should we be asking? Some of the questions people are asking are, and perhaps you've also thought about it, what will compliance with POPI cost my business? How much money is involved here? What do I have to fork out of my pocket in order to be compliant with POPI? The other question, I call it your to-do list or your grocery list. What is my to-do list for POPI made up of? Maybe you don't outsource data storage to a third party, such as neat as a pin. You do your own data storage. Then you don't have to worry about any outsourcing requirements in POPI. That's fine. That's not on your grocery list. Maybe you don't keep confidential personal information about your clients, but you do have employee personal information. They are data subjects. How are you going to handle that? The third thing that you should be asking yourself is, where should I start? What must I do first? Now that I have my grocery list of 10 things to do, you need to sit down and prioritize. Who in my practice or business should be accountable for POPI compliance? In other words, who is going to be the information officer? Could be you, could be somebody that you designate. And then you could have, if you've got branches, strongly recommend you do the deputy information officer. So you create accountability at lower levels as well, or at regional level, even if not lower. Where is all the information the Act refers to currently located in my business? I think this is critical. It's almost like when you see a map, when you walk into a rent-a-car store or rent-a-car place of business after you've just landed from a flight, and you see all those little dots on the map that says, we have branches in this province, that province, this town, etc. That's what you're going to have to do from a POPI point of view. The map becomes your business, and the little dots become what are the affected areas within your business. How will I have to change my processes and procedures to be POPI aligned? Well, you'll only know that if you do the exercise with the map and the dots. How should I approach non-compliance in my business? Now, you will need to build in, from an employee perspective, certain provisions in employment contracts, in your HR policies, to say that Protection of Personal Information Act prescribes that ABC Pty Limited, this is your company, is a responsible party, etc., etc., etc. So you're going to have to go and word your HR policies and your relevant documentation to say that any member of staff that breaches any section in POPI will be held to account. And you can manage that in however you choose to manage it, depending on how you run your organization and in line with the labor relation regulations. How should I approach reducing the costs of data storage, data administration, and data management? I would like to say to you, and it's quite bold of me to say this, but if you're not already responsibly collecting, storing, retrieving, and deleting personal information, personal data about your clients, about your staff, about data subjects, then you are not practicing a good business habit. So what POPI is asking you to do, you should already be doing in your business, because you would not want somebody else to do with your personal information in a particularly unsavory manner. You wouldn't want them to deal with it. And so too, they wouldn't want you to deal with their personal information in an unsavory manner. So do unto others as you would have done unto yourself. So it's a simple principle of good business habits. This brings us to our next slide, which is just talking about, in closing, what have we learned from session 1 and session 2. Through POPI, what do we now have in South Africa? We have a framework, we have a skeleton, we have duties, we have rights in that framework. And these are designed to provide a safety net for personal information. This framework is a balancing act, as we discussed right at the very beginning of session 1 and then again in session 2. It balances the genuine needs of organizations to collect, and note I said genuine, to collect, to store, to use, and to delete personal information for business purposes. Remember, fit for purpose? It balances that genuine need against the right of you and me, you and I, individuals, data subjects, to have our personal information kept private and to be safeguarded. So, sometimes when you do business with an organization, many times when you do business with an organization, you have to share your personal information. However, you would like for them not to shout it out on the street corners or on a microphone in the middle of a stadium. And that's what this act is saying. It's saying, how do we balance? We recognize the need for personal information to be shared, but how can we protect the data subject from that personal information being unnecessarily shared in an unnecessary platform? POPI applies to private entities and public bodies. We've discussed this in session 1, and we're just reiterating it. Now, this is important. Some people think that POPI is just about the IT guy that works in your organization. Hey, Mr. IT guy, here's a piece of legislation. Just make sure that all of our electronic data is safe, is password protected, the computer password protection mechanism comes on 5 minutes after people leave their desks if they haven't locked their computers. It's fireproof. We have business continuity management plans in place which say that we have to store the data off-site. It's your responsibility. You're the information officer. You're the IT executive. You run with this. The rest of the business, we'll just carry on with business as usual before POPI. This is a very limited, narrow-minded, archaic way of looking at information in your business. If you think your information officer or your compliance officer can do everything and be everywhere and know everything and prevent everything, then you are seriously mistaken. Because one individual cannot be held responsible for the actions of everybody else. One individual can be held accountable for the rollout of POPI within your business. That's different to that individual actually doing the POPI practices for everyone else. And this is why it is so critical to have those awareness sessions, to have those information sessions, to tell people, if you don't comply with this legislation, the company could be shut down because of this massive fine that could be levied upon us. So I think the responsibility to make your people aware rests with the leadership of the organization, and the responsibility to carry out the daily POPI activities on the ground rests with the people of the organization. And if everybody plays their part, everything will go fine. Each and every member of your organization needs to be POPI aware. It is not possible to isolate where in your business personal information will or will not permeate. Your receptionist could receive 100 copies of IDs from your clients every day. So she also needs to know. Your security guard could have an envelope dropped off in his little security office outside your offices after hours with personal information in it, and he may be privy to that personal information. Maybe the person doesn't put it in an envelope. So don't underestimate the OROS capability of the POPI Act. Don't underestimate the areas in your business where you think it will not permeate, where in fact it will. So in closing, I would like to say thank you for joining me. Thank you for your time. Thank you for listening. I hope it was interesting with all the little anecdotes and the stories. And I hope that going forward, you will know that every time you think about the POPI legislation, you will think about yourself as a data subject. You will think about your organization as a data subject, because you will do unto your clients as you would have done unto yourself. Thank you very much.